To understand the FCC's recent rules, we have to understand some of the history behind them. We can begin with the Communications Act of 1934. The Communications Act created the FCC as a 5-member commission. The statute insulated that commission from direct presidential oversight by limiting the president's power to remove commissioners based on disagreements over policy. The Communications Act gave the FCC substantial authority to regulate interstate and foreign wire and radio communications. One tool the statute provided the FCC appears in what's known as Title II of the Communications Act. Title II was designed to permit federal regulation of telephone service, in part to address the problem of monopoly. Title II permitted the FCC to regulate providers of telephone service as common carriers. Under Title II, the FCC could regulate providers' prices and terms of service. One of the critical requirements of common carrier regulation is that a carrier must provide service on a non-discriminatory basis. And indeed, a common carrier must treat a competitor just as it treats a customer. The requirement that the telecommunications service provider grant non-discriminatory access to its services fostered the development of dial-up internet access, since internet service providers could demand access to the telecommunications infrastructure on the same terms as the provider offered other services. But Title II common carrier regulation only applies to those who provide a telecommunications service. As the internet developed, one critical question was whether a provider of internet access, such as a cable company offering a cable modem service, should be classified as a telecommunications provider under Title II. If so, the FCC would have the authority to demand that the provider offer access to its infrastructure on the same terms as it offered its own services. In 2002, the FCC classified cable modem service as an information service rather than a telecommunications service. That classification was challenged in court. Ultimately, the Supreme Court of the United States held that the Communications Act was sufficiently ambiguous that the FCC, as an expert agency, ought to receive deference in its interpretation of the statute. So based on the FCC's classification of cable modem service as an information service, cable modem service was not subject to the common carrier regulations under the Communications Act. In 2005, the FCC expanded this conclusion to cover wireline broadband service more generally. So DSL, as well as cable modem services, were freed from the strictures of Title II of the Communications Act. In fact, the classification of these providers as information services precluded the imposition of any common carriage requirements on them. When the FCC issued its 2005 order on the classification of wireline broadband services, it also issued a significant policy statement on net neutrality, embracing certain principles that Commissioner Michael Powell had advanced in his speech in 2004. The FCC outlined 4 principles in its 2005 policy statement. 1. To encourage broadband deployment and preserve and promote the open and interconnected nature of the public internet, consumers are entitled to access the lawful internet content of their choice. 2. Consumers are entitled to run applications and use services of their choice subject to the needs of law enforcement. 3. Consumers are entitled to connect their choice of legal devices that do not harm the network. And 4. Consumers are entitled to competition among network providers, application and service providers, and content providers. Although the FCC did not adopt actual rules, it committed to incorporating these principles into its ongoing policymaking activities. But it stated that the principles adopted were subject to a carrier's reasonable network management. Did the FCC have the legal authority to announce and enforce the 2005 principles? That question would ultimately be resolved in court. In 2007, Comcast subscribers claimed that Comcast was interfering with their use of peer-to-peer programs by degrading peer-to-peer traffic. Invoking its 2005 Statement of Principles, the FCC ordered Comcast to cease and desist. Comcast challenged the FCC's authority to deem its actions unlawful. The FCC's principal claim was that the Communications Act of 1934 granted the FCC ancillary authority to regulate interstate and foreign communications in service of its other authorities under the statute. In a 2010 ruling, the the Court of Appeals for the D.C. Circuit rejected that approach. According to the D.C. Circuit, the FCC had failed to tie this ancillary authority to some other statutorily mandated responsibility. The D.C. Circuit's rejection of the FCC's ancillary authority in the Comcast case meant that the FCC had to abandon its net neutrality principles or rethink the statutory authority for them. The FCC responded to the Comcast decision by issuing its Preserving the Open Internet order in 2010. Because the 2010 Comcast decision had concluded that the FCC had not appropriately invoked its ancillary jurisdiction, the FCC had to find another statutory basis for net neutrality principles. The FCC focused on Section 706A of the Telecommunications Act of 1996, which directs the FCC to encourage the deployment of advanced telecommunications capabilities by using various tools, including, quote, measures that promote competition in the local telecommunications market or other regulating methods that remove barriers to infrastructure investment. The FCC claimed that its open internet rules would have precisely that effect. Substantively, the FCC adopted 3 rules. First, it had a transparency rule. Broadband providers must disclose their network management practices, performance characteristics, and terms and conditions of their broadband services. Second, the FCC adopted a no-blocking rule. Fixed broadband providers may not block lawful content, applications, services, or other non-harmful devices, and mobile broadband providers may not block lawful websites or block applications that compete with their voice or video telephony services. Third, the FCC adopted a rule of no unreasonable discrimination. Fixed broadband providers may not unreasonably discriminate in transmitting lawful network traffic. The 2010 order, like the 2005 policy statement, acknowledged that providers may still engage in reasonable network management practices. Once again in the D.C. Circuit, the order faced a challenge. Verizon challenged the basis of the FCC's authority to issue the Open Internet order, and Verizon prevailed in most respects. The court upheld Section 706 of the Telecommunications Act as the basis for the FCC's action. It also upheld the transparency rule. But the court rejected the FCC's anti-blocking and anti-discrimination rules. More specifically, the court concluded that the no blocking and no discrimination rules amounted to common carriage requirements. Because the FCC had chosen not to classify broadband internet providers as telecommunications providers, and instead had classified them as offering information services, the FCC could simply not treat them as common carriers. Regarding the anti-discrimination provisions, the court reasoned that in requiring broadband providers to serve all edge providers without unreasonable discrimination, the rule by its very terms compels those providers to hold themselves out to serve the public indiscriminately, and therefore as common carriers. Likewise, the court held that the FCC's anti-blocking rules unlawfully imposed common carriage obligations on broadband providers.